good to have you join us again on another episode of Green Footprints, coming to you from Green Grow TV studios. Well, the International Court of Justice, ICJ, has opened hearings in The Hague to determine what legal obligations states have in addressing the climate crisis and the consequences of failing to act. This hearing is actually the result of years of tireless advocacy spearheaded by Pacific Island law students and Vanuatu's diplomatic efforts. Last year, the UN General Assembly unanimously called for the ICJ to provide an advisory opinion on this urgent issue. And over the next 2 weeks, 98 countries ranging from major emitters like the UK and Russia to vulnerable nations such as Bangladesh and Pacific Island states will present their cases. This is not just a legal proceeding, but it's a critical test of global solidarity, justice, and the role of international law in combating the climate emergency. Here's the reports. The International Court of Justice in The Hague has become the focal point of a historic legal battle that could redefine global responsibilities for climate action. This landmark hearing was born out of years of relentless advocacy by Pacific Island law students and diplomatic leadership led by Vanuatu. It is set to address a critical question of what legal obligations states have to tackle climate change and what the consequences are if they fail to act. UN General Assembly unanimously approved the request for this advisory opinion in March last year, marking a major win for vulnerable nations and the global climate justice movement. Over the next 2 weeks, 98 countries will present statements before the court, highlighting the deep divide between wealthy states and a long history of emissions and vulnerable countries that bear the brunt of climate impacts.
What are the obligations of states under international law to ensure that protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B. What are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to Roman 1, states, including in particular small island developing states, which, due to their geographical circumstances and level of development, are injured or specially affected by or are particularly vulnerable to the adverse effects of climate change. Roman 2, peoples and individuals of the present and future generations affected by the adverse effects of climate change.
Conformément au paragraphe 1.
In accordance with Article 66, paragraph 1 of the statute, the Deputy Registrar gave notice of the request for an advisory opinion to all states entitled to appear before the court. By an order dated 20 April 2023, the President of the Court decided, pursuant to Article 66, paragraph 2 of the statute, that the UN and its member states were likely to be able to furnish information on these questions. By the same order, the Court fixed the time limit within which written statements on the questions might be presented to the Court.
During the first hearing, Vanuatu representative Regan Vanu told the court that countries continue to emit greenhouse gases in spite of increasingly dire warnings from scientists. Emissions have risen by over 50% since 1990, underscoring the urgency of transformative action. Meanwhile, Australia, China, and Saudi Arabia, amongst the world's largest emitters, voiced opposition to the idea of legal accountability, suppressing developing nations pushing for stronger responsibility.
The conduct on trial here is that of states, which have failed for over a century, despite increasingly dire warnings, to rein in the emissions from their territories. I must emphasize that since 1990, emissions have increased by over 50%, reaching an all-time high in 2023 last year. More than half of all CO2 emissions since 1750 were emitted after 1990. Whatever the time frame, there is no excuse. Third, a handful of readily identifiable states have produced the vast majority of historic and current greenhouse gas emissions. Yet other countries, including my own, are suffering the brunt of the consequences. When it asked the court to determine the legal consequences arising for states whose, and I quote, acts and omissions have caused significant harm to the climate system and other parts of the environment, end quote.
In the 10th opening session, debate centered around whether states' legal obligation to extend beyond existing frameworks such as the UNFCCC. While the Paris Agreement is described as a legally binding treaty, it allows countries to set their own target, which many say is a loophole that has enabled lackluster action on emissions reduction.
Climate change is now robbing our peoples from the hard-won self-determination. Melanesian peoples have been deprived of their means of subsistence, lost their territories, and suffered the collapse of their self-determined governance systems, economies, and cultures, and to bring the otherwise unheard voices of the colonized people to these important proceedings. More generally, the injustice of the climate crisis is inseparable from our shared colonial histories.
A unique feature of this hearing is the inclusion of personal testimonies from individuals already experiencing the devastating impacts of climate change. The court will publish written statements submitted during this process, ensuring that human cost of climate crisis remains central to these proceedings. This case represents a turning point in the global climate struggle. Many hope that the ICJ will use its advisory opinion to rule and bring science to the forefront and hold nations accountable under the international law. However, the pushback from major fossil fuel economies has raised concerns about the possibility of a divided outcome, similar to recent challenges faced at COP29. And in a similar unfortunate turn of events, efforts to finalize a global treaty to end plastic pollution collapsed last week in Busan, South Korea. Talks ended in dreadlock as more than 100 countries called for limits on plastic production, clashing with oil-rich nations like Saudi Arabia and Russia, who pushed to focus only on waste management. The lack of consensus led to postponing decisions until 2025, leaving key provisions on finance and production caps in contentious bracketed texts. Looking ahead to the court's decision expected in the coming months could mark a new era in climate governance, or further highlights the lack of consensus in global climate action. The world waits with bated breath as the ICJ deliberates over this monumental case in The Hague. As the ICJ hearings unfold, the stakes for global climate action have never been higher. The emissions still rising and vulnerable nations bearing the brunt of the climate impacts. The world watches closely, hoping that this historic process will lead to clearer accountability and a more decisive action. While the developed nations seem to resist binding legal obligations, others see this as a moment to elevate science and the realities of climate breakdown to the forefront of international law. The testimonies that would be presented, including deeply personal accounts and those already living through the consequences of inaction, remind us of the human cost of this delay. This, like I said earlier, is more than a legal debate, but a call to action. Many thanks for watching. I'm Tony Gubanjo. It's bye for now.